I have received an apology from Honorable Horn, but I see he has joined, that he is attending to some party matter. He will join us tomorrow. That is the apology I've received. I'm not sure whether there are any other apologies.
Chair, I think Mr. Horn is on the platform. These plans have changed.
Oh, okay. Okay, no, thank you very much. Are there any other apologies? I see Honorable Janji is also, yes, I think Honorable Janji has also joined. Honorable Horn, your hand is up.
Yes, thank you, Chair. Yes, in fact, my plans have luckily changed somewhat. I will be available or with the committee until at least 11:45. Thank you.
Okay, no, that will be good. I think we should be done around that time. If we're not done at 12, I will have some challenges for a few minutes, load shedding. Then I will try and reconnect, but let's try and push that we should be done by 12. Honorable members, I think we need to start. I think we agreed last week that members who would want to make submissions, they are allowed to do that. And they should submit by yesterday. We have received 2 submissions, one submission from Honorable Horn, and then another submission on Honorable Maseko Jele. I proposed the following process, that we would first allow honorable members to make their presentations on their submissions. And then after each presentation, there would be a discussion. Then the department, in fact, after each presentation, then there would be a discussion, question and answers. And then the department would respond. We go to the next presentation. Same would apply. Then we would go back to the issues that we asked the department to go and do further work on, and then we would also get the presentation from the department, and then we'll have discussions. Hopefully today we would have a clearer way forward as to how far are we going with this particular bill. And I've also received from Honorable Horn a request that they might want to make further presentations at some point on the hate crimes bill. And I would suggest that anybody who would want to make any further points, at least we get those submissions by next week, Monday, because it's not a long bill. Next week, Monday, any other area of the bill that we might want to make submissions on, if we can agree that by Monday, in fact, let's say Tuesday, we have those submissions made. I think those are the preliminary issues that I wanted to raise before we proceed. I have Honorable Swart and Honorable Yako in that order.
No, thank you, Chair. From our perspective, the ACDP did make an initial submission. Obviously, things have changed since then. I just wanted to, so we appreciate the opportunity to make further submissions should it arise. But I'm sure as we're going along, we will still be allowed to suggest word changes here and there. I think, is that correct that you're talking about broad submissions such as what Mr. Horn submitted, and Ms. Jelly, which were, I haven't read Ms. Jelly's yet, we only got it this morning, but Mr. Horn's was very helpful with general legal principles and things. So I appreciate the opportunity, but I presume as we're going along, obviously one can still make submissions just on wording as we're going along. Like
yes.
Yes. Thank you so much, Chair.
That will be helpful. That will be very helpful. That would be very helpful, Honorable Swart. Honorable Yako.
Enkosi kakhulu Hlalo. I just want to say that thank you very much for the opportunity to give us another chance as parties to submit, because I know that I was not present last week. So I think I might have missed that communication that we could send submissions this week. But I wanted to just put it on record that the EFF will be sending a submission on its on its thoughts around the bill before Monday. Thank you.
Okay, thank you very much, members. So are we agreed on how we are going to be managing the process today, that we allow Honorable Horn to make a presentation on this submission, and then followed by Honorable Jelle? In fact, after Honorable Horn, we have discussions, and we go to Honorable Jelle's one, and then we go to the department's submissions. Is that acceptable, members?
Agreed, Chair.
Yes.
Just a suggestion, can the department not also respond to each member's submissions after they've made it? I mean, there can be discussions would be useful, I think, rather than the department responding to both at the same time, because there are slightly different aspects that the department is able to respond after. Let's say, can we not say there's questions? Honorable Horn will make a submission. There's then questions from members or from the officials to that. Then the department responds. Then there's a discussion on his. Then we move to Honorable Maseko Jele's submission.
Yes, that is what I thought. That is what maybe I was not clear. I was not clear enough. That is what I was suggesting, Honorable Deputy Minister. Thank you very much. Can we allow Honorable Horn to make his presentation?
Yeah, thank you, Chair. As it is, I'm unfortunately on a device where I can't share my presentation, but it was circulated early yesterday, so I will, with your permission, take it as read. I see the Secretariat is assisting there.
But it is taken as read, Honorable Horn. You can proceed. I think if the Secretariat is able to flight it, it's fine. But members have had an opportunity to go through your presentations yesterday. But I think it's important for the public to see it. And I think the Secretariat has kindly done that. Thank you very much to our Secretariat, so that the members of the public can go through the presentation as you are presenting. Please proceed, Honorable Horn.
Yeah, thank you, Chair. So our submission starts off by identifying through the case law, and specifically, firstly, the Islamic Unity Convention case, and then the EFF case, that our Constitutional Court has made it fairly clear that the criteria set out in Section 16(2) of the Constitution by our Constitution makers ultimately is criteria in respect of which our freedom of speech or our right to freedom of speech is not covered, does not extend to speech that falls within Section 16(2). And I think that's important for us ultimately in processing this bill and contemplating criminalizing hate speech, in the sense that it's quite clear then from those specific cases that our understanding must be that those criteria obviously would then call or criminalization in respect of speech that falls within those criteria would require a much simpler test and exercise. so if we scroll down there, then Chair, the point is made that speech within section 16.2 of the Constitution is not it's ultimately unprotected speech, and then therefore it must follow that for us in dealing with criminalization, speech, hate speech on the basis of race, ethnicity, gender, and religion ultimately would then achieved by way of a simpler exercise. But then in paragraph 6, it is of course also, we also reminded there that in Kwalani, even though criminalization of hate speech was not the issue there, the court made it quite clear that in the view of the court, criminalization or criminal sanctions in related to what is called unlawful form of expression, so that would include those forms of unprotected speech, must be seen as a last resort measure and be applied in only strictly justifiable situations. And then if we add to that the content of paragraph 7, we then on the basis of that say, yes, it is a simpler exercise in respect of hate speech based on those 16.2 criteria, but it might still be necessary for us as Parliament to satisfy ourselves that the measures contained in the current legislation has been insufficient in rooting out and preventing, well, discrimination and hate speech on those grounds, in order to satisfy the yardstick set by the Constitutional Court, which is referred to there in paragraph 6, which says that it must be last resort measures. So firstly, I think our reading then of the case law is that in respect of hate speech based on race, ethnicity, gender, and religion, we must, I don't know whether it would ultimately be the Human Rights Commission or other experts, must at least come and place on record before the committee that the current measures have been unsuccessful in addressing the type of discriminatory behavior and specifically hate speech based on those specific criteria. If we then go to paragraphs 8 and further, Chair, the court in EFF also made it clear, and of course we in the submission said that these we take our guidance mindful of the fact that of course it was the incitement in terms of the Riotous Assemblies Act that was at issue in EFF. But what is important there in the section in bold there quoted in paragraph 9 is that the court there introduced a requirement that what was called serious harm, danger or serious harm should be present in order to criminalize speech. And that I think we believe is important for the purposes of when we talk about the definition of hate speech for the purposes of this bill. It's quite clear that at this stage, and I think all of us did it, Chairperson, is that we took our guidance from Kwalani and the definition of hate speech there, but ultimately did not up to now consider that specific definition, of course, related to the provisions in terms of PUDA, which did not include criminal sanction, and that this specific paragraph in EFF ultimately calls on us to consider whether the same definition of hate speech could apply in respect of criminal hate speech. Then in paragraph 10, Chair, what we do there is to to attempt to also look at the serious harm or danger as introduced in the previous paragraph, just to again stress that the reference was not done in passing, but actually in two of the substantive parts of FF. And then if one takes both the remarks in 46, which says it must be more than potential harm and there must be serious harm or danger, we conclude on the basis of that, Chair, in paragraphs 11 and 12, that it would seem that the court is of the view that there must firstly be for criminalization purposes a serious risk or potential for harm, but then because the court said that there mere potential harm there in specifically paragraph 49 quoted in our paragraph 9 is not enough, it would mean that the court, in our view, ultimately guided us to say that for criminal purposes, there must firstly be a serious danger or potential for serious harm, but then ultimately also for purposes of criminalization, the potential itself would not be sufficient and the harm must materialize. That's at least at this stage our reading. Of course, it might be that the department interprets this otherwise, and then as a committee we will need to consider carefully how we approach this. Of course, I don't in any way or form profess to be a constitutional expert, so quite possibly one of the things I at this stage already want to say is that this is our reading, but of course it might also be necessary for us to take external legal advice from the real experts in this field as to whether this reading is correct. Chair, therein, then furthermore, in paragraph 14 and 15, which talks about the justification analysis, the court talk about reasonable grounds and good reasons for interference, and that's of course then specifically if we are to include those criteria or grounds that goes beyond the list contained in section 16.2. And I've quoted at length there from EFF as well in paragraph 15 certain sections, and why I specifically included this, Chair, is maybe also just to say that we as Parliament, the committee representing Parliament in the processing of this bill, ultimately must have a clear understanding also of our duty in this regard. It's interesting that the court, both in Kwalani and in EFF, talked about the way the courts go about to scrutinize whether Parliament in making laws have overreached when the right to freedom of speech is limited. But my strong argument, Chair, is that those specific, let's say, the protocol for the court to determine whether Parliament has overreached actually also in a very clear way delineates our responsibility. So it's our responsibility ultimately, having sworn an oath of allegiance to the Constitution, to not overreach. And in this regard, and it's not to pick fights, it is specifically stated, Chair, that when the executive introduces a bill, I think the court uses the word the state there, which I think in our context would mean the executive. It is ultimately for the executive to come and justify properly before the committee the inclusion of all of these additional grounds. And I've specifically quoted that, Chair, just to maybe underscore the massive duty we have in this committee, ultimately, specifically in scrutinizing the suggested expansion of the list, or the grounds on which free expression can then be limited and even criminalized. In 16 and 17, Chair, I think also for the purposes of criminalization, it is very important for us to note that whilst in EFF, the clear purpose of the limitation of free speech was the prevention of crime, whilst we argue there in 17 that the purpose of limitation and specifically hate speech provisions, whether it's criminal hate speech or not, ultimately speaks more towards the aspirational parts of our constitution and the type of society we want to establish. And in that sense, it would seem, therefore, that the previous remarks by the court that criminalizations should be an absolute last resort would also tie in with the fact that it cannot be said that limitation of free speech by criminalizing hate speech beyond section 62 of the Constitution has a purpose of really preventing crime, as it is in a somewhat ironic or circular way. We are now to criminalize something. So at this stage, we cannot say the purpose of clamping down on free speech is to prevent the crime, because the crime is not yet there. Then, Chairperson, in 18, 19, 20, and 21, well, actually up to 20, I've included this part as well, again, Chair, because I'm strongly of the view that this is the manner in which we should take guidance from the court. So we are, of course, thankful for the fact that the department has already dealt with the issues of conscience and belief by way of the remark of the court in Kwalani in paragraph 128. But our strong view is that this was mere examples of the possible problematic expansion of the list, which the court tabulated there, based also on the remarks of the friends of the court in Kwalani specific. But that if one considers that in context, it can't mean that has settled the issue around a further expansion of the list. Paragraph 21, Chairperson, I've specifically included here because of the argument that has been put before the committee that there is a justification for the expansion of the grounds or the criteria to be found in the list that is both in the Constitution itself, in the anti-discrimination clause, as well as then in Papuda. And this paragraph in Kwalani just must serve as a clear guidance to us that it is unfortunately not as simple as this, in the sense that speech in terms of section 62, as previously pointed out, is unprotected speech, and then the list or the grounds set out in the anti-discrimination clause in Papuda ultimately serves a different purpose, in the sense that up to now, there would be a duty on a respondent to show why discrimination on those grounds would not be unfair. So it's not as simple as saying that the dignity assessment has already been done in respect of those. It is, if I understand the specific paragraph 130 in Kwalani correctly, it is not as simple as saying that any speech that sentence on these grounds or can be brought home in terms of these grounds are there's already an infringement in the dignity of those at which the speech is directed automatically. And in that sense, it is therefore, once again, not as simple as just merely borrowing from those other lists in both the Constitution and other legislation. A specific exercise will have to be done. Once again, Chair, if we scroll down to paragraphs 22 and 23 there, a very specific exercise will have to be done by Parliament ultimately to ensure that we extend the list in a valid manner, even though those lists might already be applicable to what is called vulnerable groups. But there in paragraph 23, the court in Kwalani in very clear terms said that there must be not only membership of a group, but systemic discrimination and the undermining of the dignity. And that's ultimately the yardstick we believe that must be applied to all of the suggested additional criteria. Then paragraphs 24, 25, 26, and 27, Chair, we just again suggest a way forward. The court, Belani, clearly placed, with good reason, a heavy reliance on the expert evidence that was presented not before the Constitutional Court, but ultimately the court of a first instance. And in that sense, we believe that much of the same will have to happen before this committee in order for us to, in a reasonable and rational manner, expand the list. And then in the last paragraphs there, 28 onwards, we again make the point, Chairperson, that as Kwalani has put it, there is a clear definition by our court in the acceptance of the definition settled on by the Supreme Court of Canada of what hatred is, and we suggest that must also be included. In paragraph 31, 32, and 33, Chair, we deal somewhat with the way in which harm has been defined up to now in the bill. And what we point out is that whilst we're dealing with criminalization, we have a big question mark around the possibility of expanding the definition of harm to that beyond what has been found to be the types of harm that is relevant to hate speech in the non-criminal context. So in that sense, we suggest that, for example, cultural harm, which we, through our research, have not been found as a concept in our law at all up to now, that it could be very problematic to ultimately include that in the definition. And then 34, 35, 36, those paragraphs ultimately just points out that as a consequence, we're also of the view that the so-called exceptions must be relooked, specifically in light of also the remarks by the court about the seriousness of well, firstly, the seriousness of the potential harm, and then the realization of harm. And if we ultimately accept that that would be the requirements for criminal hate speech, then of course the exceptions must be redrafted as well. And then in 35, we make the point that quite possibly also for us to settle on a law that can pass constitutional muster, it might require of us to distinguish between hate speech that must still be dealt with by way of interventions other than criminalization and possibly reserve criminal criminalization of hate speech only for the more egregious examples of hate speech. In our view, that would ultimately give the bill the highest possibility of of passing constitutional muster. And then, yeah, paragraph 36, there's just a remarks in summing up the submission we're making, to say that the definition of criminal hate speech, in our view, needs to be relooked at. The definition of harm, the definition of hatred, the expansion of the list in light of these remarks and findings really by our constitutional court in those two cases. So maybe, Chair, as a say that we believe, in terms of our reading of these two cases, that both the substantive part of this bill needs to be carefully looked at, but similarly, the committee must, in our view, reconsider carefully the process that we will be that we must follow in order to, in a valid manner, contemplate extending the list of criteria beyond what is set out in section 16.2 of the Constitution. And it's our strong view that it can't, justification can't be a simple an exercise where we are merely informed that these criteria are extracted from existing legislation and the product of the views expressed during public participation. In our view, because it is ultimately boils down, everything beyond section 16.2 of the Constitution boils down to a limitation of the right to free speech. There must be a very careful and deliberate exercise through which we must satisfy ourselves that there is a pressing need to include those criteria in the criminalization of hate speech. That doesn't mean that those criteria might not in other circumstances be relevant to non-criminal hate speech, but for us to satisfy our constitutional obligations, we strongly advise that we must carefully look at how the process we followed in terms of the suggested expanded list. Thank you, Chair.
Thank you, Honorable Horn, and thank you for the presentation. Members, any comments, questions? Honorable Nebo, Honorable Swart, in that order.
Morning, Chairperson, and morning to everyone on the platform. Thank you very much, Honorable Horn, for your presentation. In my mind, I'm still lacking the words of protected speech. Does it mean there is protected speech and not protected speech? So the bill also has the definitions. What constitutes protected and not protected? I think that part I'm still not very clear on. I'd like to get more detail, please. Thank you, Chair.
Thank you very much, Honorable Nebotruchen. Honorable Swart.
Thank you, Chair. Yes, I want to thank Mr. Horn for the submission. I think it is compelling. There's a lot in this, a lot of which we agree with, and I think we need to take it one step at a time. Whilst I appreciate that it is up to the department to persuade us as to the inclusion of broader definitions of harm, of all the characteristics, at the end of the day, it's us as Parliament that will reach the decision, and we might differ from the department on certain issues. Because bear in mind, when the Constitutional Court considers these matters, it normally gives an order against Parliament as we are the legislative forum at the end of the day, that are held accountable for any provisions that are unconstitutional. So I'm particularly interested in the issue relating to the fact that current measures, as far as hate speech is concerned, have allegedly not been successful. Now, I raised this previously, and I do remember that the answer to that was that the current legislation or the common law, such as criminal injuria, only pertains to individuals and not to groups. So that is another balancing act when one has to consider on constitutionality, on limitations. I think the issue relating to what was said in the EFF judgment is very important when it comes to the balancing, the proportionality, the limitation of the right, given the fact that in international law, even in the African Charter, a lot of focus is expressed on protecting the right of freedom of expression. And I think it's also helpful to bear in mind that in the Kwelani judgment, again pertaining to a civil remedy, it was made very clear there that hate speech is speech that goes beyond mere offensive expression. There's a much higher bar. It's understood as extreme detestation and extreme vilification. And I think there's a much higher bar than we are accepting here. It's not an expression that is merely hurtful or as the court says, or in everyday parlance, or insufficient to constitute. That would be insufficient to constitute hate speech. So I think we need to appreciate what the courts have already said. And I appreciate, Chair, that you've allowed, and that this is going to be a very detailed and time-consuming exercise to ensure that the bill which we pass at the end of the day meets the constitutional muster. And our beginning point must be section 16.2, and then we've got to look at section 36 limitations, and then we'll have to, as you've already agreed, we'll have to then understand the inclusion of any characteristics, broadening of those concepts to ensure that the test of reasonable and justifiable limitation on freedom of expression, that test is met. So there is a process. There's a process, and I appreciate the input, which we largely agree with. Let's take it one step at a time. Thank you, Chair.
Thank you very much. Are there any questions by the department? Or comments?
Nothing from my side, Mr. Chair. I don't know whether my colleagues would like to maybe raise some questions for purposes of clarification, but from my personal point of view, I think the document was well written, and we've taken note of the line of argument being taken. Thank you, Chair.
Thank you very much.
Chair, sorry, I think the issue is of whether there are any questions, but then if not, the department and I think Mr. Dupree will respond to the submission. I've got some points to add, but I would like to come after he's started.
Okay, so you will come when, okay, no, that's fine, which means we can go to Honorable Jeller's.
No, Chair, I wanted to suggest that because we are discussing this input, that you do get the response from the department to this input now.
Okay. The challenge, DM, is that Mr. Dupree said that no, he's got nothing to add.
Well, I think he misunderstood the issue. I mean, my understanding is the department is going to respond. I mean, that's from the department side. So I think he was talking about he had no questions, but we're not just noting the submission. Okay.
Can you respond to the input, Mr. Dupree, if you have a response?
Chair, my apologies. Chairperson.
Honorable Hon.
Yeah, I don't want to prescribe the process, but Ms. Nivo Drachen asked one specific question. I think Mr. Swart made more general remarks. May I just maybe address her question
Oh, okay,
before the
that's
department?
fine. No, that's fine.
Okay.
It's fine.
Thank you, Chair. Yes. What we must understand is that the courts have held, and I think correctly so, that Section 16(1) of the Constitution sets out the freedom of expression or speech, as we call it, which everyone enjoys. And then in Section 16(2), certain grounds are identified to which, as the Constitution itself says, this right to freedom of expression does not extend to. And those would then include propaganda for war, incitement of imminent violence, and then in paragraph C, the basis of our current, all hate speech provisions and possibility to expand on hate speech provisions in our country. Paragraph C, which says no protection is given if there is advocacy of hatred that's based on race, ethnicity, gender, or religion, and which constitutes incitement to cause harm. So those would then be the unprotected speech, to answer the Honourable Nivo Drachen's question directly. No protection could ever be afforded by us as the legislature to speech that satisfies these provisions. However, if I understood the court correctly in Kwalani, and specifically again my submission paragraph 6, where I quote from paragraph 90 of Kwalani, the court still holds the view that even though the protection of your right to freedom of speech would not be in place for speech set out in Section 16(2), to criminalize it, because the court there said, we quote approvingly from the United Nations Rabat Plan of Action, to criminalize unlawful forms of expression. So that would include unprotected speech. It must still be a last resort measure. And in that sense, I think the remarks of the Honourable Swart is quite applicable, in that we must, even if we are to criminalize this, as I said in my submission, I believe it would be a much simpler exercise.
Sorry, Honourable Hon. Honourable Nivo Drachen.
Yeah, sorry. The interpreter's network cut off, so she missed quite a lot of Mr. Horn, what he said. He can go back to what the court said in the Kwalani judgment. That part. Sorry for that.
Honourable Hon, can you start there?
Yes. Thank you, Chair. Yes, so in paragraph 90 of Kwalani, the court said that it's of the view that our approach to possible criminal sanctions for any form of speech or unlawful forms of expression, as the United Nations Rabat Plan of Action is that it must be last resort measures. So in that sense, I do believe, even though on our reading, it would be a much simpler exercise to say that the time has arrived to criminalize speech that does not conform to or satisfies the definitions set out in Section 16(2)(c). It may still only be done as last resort measures. And in that sense, I believe both our submission and the input today of the Honourable Swart makes mention of the fact that we at least must follow a process in terms of these provisions to satisfy ourselves that the current legislative framework has been unsuccessful in dealing with speech, hate speech, on the basis of those 4 criteria set out in the Constitution. So maybe to sum up, Section 16(2)(c) states speech that can never be protected in our country. So it's the type of speech based on our specific history and our specific the specific context given by our history, which can never be protected. But nonetheless, it would seem that for us to criminalize it, it is also not as simple as merely making a policy choice. We must, as Parliament, still be satisfied that the current measures have not been successful in rooting out that type of speech. Thank you, Chair.
Thank you very much. Mr. Dupree, responses?
Thank you, Mr. Chair. And I would like to apologize if I created the impression with the committee that for the mere fact that we didn't ask questions on the submission that was made, that we wouldn't respond. So I apologize for that, Mr. Chair.
No problem, no problem.
Thank you, Chair. Mr. Chair, I think, and in the presentation this morning, the word take guidance from Kwalani was used, and the department has already in previous meetings of the committee indicated that we would like to take guidance from the Kwalani judgment. We are not approaching it as the be all and end all. That in short, Mr. Chair, and please excuse me if I'm going to provide you with a long-winded response today, but there are a number of issues that I think the committee should note, and I would also like to provide my colleagues, my DDG, Ms. Pillay, and then also my team member, Ms. Botha, to maybe add if they have anything to add. But what I would like to point out to the committee, first of all, I think, and we've received the proposals in the committee by interested parties that well, if I say we, Parliament should restrict itself to the grounds contained in Section 9(3) of the Constitution. Before I get to those grounds, I would like to point out, Mr. Chair, that 16(2)(c), first of all, has a test. It doesn't only refer to the 4 grounds. The test is that speech based on those 4 grounds constitute incitement to cause harm. Now, I would like to point out to you, Mr. Chair, if you read the proposed new definition of harm in line with Clause 4, Clause 4 has been tightened up as a result of the guidance received from Kwalani. The proposal is also to tighten up the definition of harm. So that places us in a much different position than we were compared to the bill as introduced. The department, to a certain extent, Mr. Chair, is concerned about the fact that there might be an overemphasis on the 16(2)(c)(4) grounds and possibly even the 9(3) grounds or characteristics, if I may call them that. The department's approach in this regard, Mr. Chair, is that we are concerned about that overemphasis because we are not really taking the victim's situation into consideration. The grounds are there, yes. If you want statistics on how many cases of hate speech took place in the past 10 or 15 years, it will only be anecdotal information that the department would be able to provide. But I would like to maybe just, with your permission, Mr. Chair, take the committee back. And if I remember correctly, I think it was only Mr. Horan and possibly yourself sorry, Mr. Swart and yourself, who were members of the committee, and of course, my deputy minister, when we promoted the Sexual Offences Act through Parliament, we were in a position where we recommended that a grooming provision should be provided. But the department wasn't in the position to indicate to the committee how many cases of grooming take place on an annual basis. But it's not a question of how many cases. It's a question of it's going to happen. We know it's going to happen. So what we would like to argue at this stage, Mr. Chair, is that one would like to be, or the department would recommend that the committee should approach this identification of the grounds in a forward-thinking manner. One would, as a drafter, be very disappointed if a classic example of hate speech takes place, but the case cannot be prosecuted because that specific ground has been left out. Now, you are aware, Mr. Chair, and we took the committee through at the previous meeting through the working document. The department came up with or proposed to the committee a new and shortened list with regard to the grounds. So what I would like to highlight to the committee at this stage is, I think the important thing at this stage is to recognize that clause 4, read with the definition of harm, is drastically stricter and narrower than compared to the bill as introduced, among others, as a result of the guidance that the Kulani judgment has given the department or the legislature. And I would like to maybe leave it at that, Mr. Chair, and if there are then any questions or responses, I will respond to that. Thank you, Chair.
Thank you very much, Honorable Deputy Minister.
Thanks, Chair. I don't know if there are any other responses from Ms. Botha or DDG Pillay.
DM, I would like to, Honorable Deputy Minister, I'd like to make a few points in addition to what Mr. Dupree has just said, if I may, Chairperson.
Please proceed.
Thank you very much, Chairperson. Just a few points that I want to highlight and perhaps summarize on the basis of what Mr. Dupree has already said. I think there are certain points that we all agree on, and that is that the freedom of speech is in Section 16 of our Constitution. And Section 16.2 already provides those grounds that are already proven and which we all accept, that is where we may not breach freedom of expression. We all also agree that the expansion of the list is permissible, but subject to Section 36 of the Limitations Clause. And that is that we may not unjustifiably limit the rights in the Constitution when we are drafting legislation and when we have to have a rationale for it, and we may not, the courts then interpret whether we have breached Section 36. And Chairperson, I think the rationale, and just to add to some of the points that Mr. Dupree spoke to, and that is that we want to cover some the areas where we want to be preemptive, but over and above that, there are more important, there are other important areas that we want to cover in respect of the rationale. And that is a question that we must ask about, where the first question is whether the current law is sufficient in respect of hate speech. Currently, what we have is the offense of crimen injuria, and clearly that is not a sufficient criminalization of hate speech as it currently stands, as it does not give sufficient recognition of the crime of hate speech. And in introducing this bill, the executive considered all these issues and the ongoing attacks on the grounds of several of the grounds, such as race, the issue of attacks against LGBTQI people, etc. So when we look at the issue of, I just want to quote from a research document that we have on whether PEPUDA itself is also a sufficient framework which provides for the, PEPUDA, as we know, provides for the civil action, for the civil remedies. And I just want to go to the, should related concepts, so there's a paragraph that reads in our document, should related concepts be included in legislation on hate crimes? And it says there has been some discussion of including hate speech and general discrimination, such as denial of services or employment based on characteristics such as race or nationality in legislation on hate and bias crimes. The Hate Crimes Working Group recommends that hate speech and discrimination are not specifically addressed within this legislation. The Promotion of Equality and Prevention of Unfair Discrimination Act, PEPUDA, is aimed at preventing unfair discrimination and protecting dignity as contemplated in Section 9 and 10 of the Constitution. In addition, Section 10 of PEPUDA specifically addresses the prohibition of hate speech. Hate crimes differs from hate speech and discrimination in general in that in hate or bias crimes, the base offense is still a crime. So an assault, regardless of whether motivated by hate or bias or not, remains a crime. The same does not apply to discrimination per se or hate speech. So that's one issue that I wanted to raise. I think, Chairperson, in regard to the cases that have been quoted, and quite correctly so, and very interesting because they are the latest cases that looked at hate crimes and hate speech, the Kwelani judgment and the EFF judgment. However, I think the EFF judgment must be read in its context. It's about incitement to commit an offense. It's also to be read within the historical context of the passing of the Riotous Assemblies Act and how that act is currently still on the statute book. And I think the department was criticized for not having dealt with this piece of legislation a long time ago as an apartheid era statute. So I think that is the context that we've got to look at. And then finally, two final points, Chairperson, in respect of our international obligations to to criminalize hate speech that can be found in ICERD Article 4. And when ICERD was presented to Parliament, I believe the Joint Committee also dealt with the issue of dealing with criminalizing hate speech. And we can probably go back to those records, but I don't think it is necessary because ICERD Article 4 exists. And one of the rationale is that we want to give effect to that obligation. And then finally, Chairperson, I just want to make this point, and Parliament must obviously look at the context of the legislation within the Constitution. Section 44(4), just to read it, when exercising its legislative authority, Parliament is bound only by the Constitution and must act in accordance with and within the limits of the Constitution. So I think the interpretation that the courts take, the interpretation methodology that the courts follow when they are interpreting what Parliament does is an important aspect for Parliament to say, but if we pass this legislation, this is how it may be interpreted. It's important to do so, but Parliament has the power to pass legislation that does not exist in our law currently, and we are bound only by the Constitution and what we deem to be constitutional. Thank you, Chairperson.
Thank you very much, Mr. Dupré. Your hand is up.
Thank you, Mr. Chair. And I would just like to add to the last point that Ms. Pillay made, and that is to point out to the committee that, and the committee has been or received comments by interested parties that suggests that only the grounds in section 9.3 should be included in the bill itself. But I would like to maybe point out to the committee, it's actually clause 9, section 9.3 and 4 of the Constitution, because 9.3 is about the vertical relationship between the state and individuals, and then 9.4 is, of course, the horizontal relationship. But I would like to maybe just register this thought with the commission, with the committee, that 9.3 is not a closed list. It's an open-ended list. Thank you, Chair.
Thank you very much, Ms. Botha.
Thank you, Chair. Sorry, I just want to add on to what my DDG and Mr. Dupree have said, and the point that I want to make is specifically in relation to the justification or the limitation, the section 36 limitations analysis test. And if I may, I'd like to just read a quote from a Constitutional Court case, which is Minister of Home Affairs versus the National Institute for Crime Prevention and the Reintegration of Offenders, NICRO. It's a 2005 case, and the Constitutional Court at paragraphs 35 and 36 say that the burden to justify a limitation in legislation calls for a different inquiry to that conducted when factual disputes have to be resolved. There may, for instances, be cases where the concerns to which legislation is addressed are subjective and not capable of proof as objective facts. A legislative choice is not always subject to courtroom fact-finding and may be based on reasonable inferences unsupported by empirical data. When policy is an issue, it may not be possible to prove that a policy directed to a particular concern will be effective. It does not necessarily follow from this, however, that the policy is not reasonable and justifiable. If the concerns are of sufficient importance, the risks associated with them sufficiently high, and there is sufficient connection between means and ends, that may be enough to justify action taken to address them. And this tracks back to a point that was made in the committee previously, that we simply don't have the empirical data. The NPA does not have data relating to offences which are motivated by bias or prejudice. SAPS does not keep record, and they don't keep that data. So we simply don't have empirical evidence. It takes the form of anecdotal evidence. And the reason why this case is important is that it shows that a policy objective and an explanation of the policy and the reasons underlying the policy can sufficiently justify a limitation. Thank you, Chair.
Thank you very much, Honorable Deputy Minister.
Thanks, Chair, and thanks to the department. Look, I think they've generally responded just on the last point that Ms. Botha raised. That was a judgment from Chief Justice Chaskelson. But DDG Pillay had also raised, when Honourable Horn raised the question of in his paragraph 9 and the reference to paragraph 46 of the EFF Writers' Assembly Act case about the crime needed to have, it wasn't sufficient to protect from potential harm. That's because it was, as DDG Pillay says, that they're talking about incitement, and hate speech is not necessarily incitement. Hate speech in terms of what's in the bill and what's in Papuda is harmful. It must be harmful or incite harm. So that's an option of incitement, or it must promote or propagate hatred. So reading out hate speech can be harmful or promote or propagate hatred, as well as inciting harm. So I just think those aspects need to be looked at. The And so it's not about preventing crime so much. It's what is said is a crime in itself, because it can be harmful to the person or the group, because it can promote or propagate hatred, or because it can incite harm. I think there's this general agreement that obviously with hate speech, because it is limiting free speech, we need to be very careful and be able to justify in terms of the limitation clause what grounds we are putting. I mean, to my mind, the issue is, as we've said, the definition of harm and then the grounds. We can take each of those grounds and go through them, and maybe that exercise can follow later at some point to justify why those are in. The committee can disagree and want them taken out, or they can want other grounds put in. So we can do that, but I think it's important also that we do make progress on the bill. This bill is, I think, the longest, the highest up on the order paper outside the state Protection of State Information Bill, which was referred back to Parliament. This bill hasn't been referred back. So whilst I appreciate the fact that there's a lot of deliberation and thought going into this, it also mustn't become a mechanism for delaying a bill the parties don't want passed. We know that the likelihood of the DA supporting this bill is pretty slim. That the chairperson of the DA, Helen Ziller, called a press conference on this bill during the local government elections. The press conference didn't happen, but presumably she felt at least her own view, and presumably the party would agree with her that this was of sufficient import during the local government election campaign to criticize this bill. So I do think that I do thank Honourable Horn for his input. It is very reasoned, thought out, but for me, the gist of it is that, I mean, yeah, that we do have to ensure that we comply with the limitation clause and other measures mentioned in the judgment in terms of ensuring that the definition of harm and the categories of the grounds rather for hate speech. Just to say, to remind honourable members that PAPUDA does, it is a civil remedy, but PAPUDA does envisage criminal action too. So 10.1 is on 10 is the prohibition of hate speech, 10.1 is the prohibition, and then 10.2 is without prejudicing the remedies of a civil nature, the court may refer the matter of any case dealing with the publication, advocacy, propagation, or communication of hate speech as contemplated in subsection 1 to the DPP. So it's part of the PAPUDA package. So Chair, yeah, just to add those points. Also in terms of the grounds in PAPUDA, Parliament, I mean, Honourable Swart, I think, was there. Parliament didn't bring in experts to say which ground should be in or out. It was Parliament applying its mind. So just to make that point, but thanks, Chair.
Thank you very much. I think what we will do, a person who has introduced a topic like the presenters, in this case, Honourable Horn and Honourable Jelle, would be allowed to close the debate, because to close for the purposes of the presentation that we have had. So can I give Honourable Horn to do that, so that we can, after that, invite Honourable Maseko Jelle?
Sorry, Chair, I just didn't follow the DM's one point. I'd like to just ask him if I may.
As much as we can do that, members, but I think it would also be important that we are not closing the debate. We are still going to come to these issues. I would appeal to members without prescribing to them. that we must find a way of, for now, for the issues that have been raised, we must move towards some allowing Honorable Horn to make some remarks so that we can be able to take Honorable Masego Jele's input. Then we go to what we have asked the department to do. I think the issues that have been raised have raised a lot of other things, a lot of other thoughts. But if members still want to, I would really appeal that just for the sake of trying to manage time, we are not closing any of these issues. I mean, from how they've been raised, it's quite clear that we're still going to engage forward. Honorable Swart, do you still insist?
It's just a question of clarity. I just wanted to understand the issue of incitement in section 16.2. For me, as I understood the DM to say, it doesn't, incitement is not a requirement, but if you read 16.2, it says and. So I just wanted to understand that because I might be reading it incorrectly, but the and to me would imply that incitement is included in that. So we might differ on that, but I just wanted to check the wording of section 16.2 at the end. Thank you, Chair.
Thank you very much. I think it will be part of the ongoing debate that we're still going to have on the bill. Honorable Breitenbach, do you still want to continue? Do you still want to raise your hand?
It's fine, Chair. I'll wait. We can continue.
Thank you very much. Honorable Horn, can you wrap up on this issue?
Yes, thank you, Chair. And maybe in wrapping up, allow me to just briefly, from my side, make one or two comments in response to the department and the Deputy Minister's comments. The first is around justification, Chair. And I firstly want to say that I think that the argument to say that when we dealt with the sexual offences legislation, we basically did not demand or require, because it was not available, empirical evidence, I think cannot just be applied in the current circumstances. When we dealt with the sexual offences legislation, there was, of course, no tension between different rights. No person has a right to sexually offend against another. So that legislation was firstly not about balancing of rights or justifying a limitation of a specific right, because the actions that were at the issue in sexual offences legislation did not limit any of the basic rights we all enjoy. So that let me also then use that to jump to the reliance of Ms. Botha on the Minister of Home Affairs versus NICRU. I've quickly called it up. I, of course, would want, with your permission, the benefit to study it a bit further. But just at a cursory reading of paragraphs 35 and 36, it's unfortunately not, to my mind, as simple as saying that you can, in all circumstances, act in making legislation without supporting empirical data. Paragraph 36, as a matter of fact, makes it clear that one must distinguish between circumstances where you must source and acquire empirical data and where it will be possible to proceed without it. Paragraph 36 starts off by saying where justification depends on factual material, the party relying on justification must establish the facts on which the justification depends. Now, I would want to maybe just ask the department to consider, given our submission today, and specifically that specific paragraph 90 of Kwalani, where the court said criminalization of unlawful speech must be a measure of last resort, whether they won't agree that even if one then considers Minister of Home Affairs versus NICRU, this is exactly that specific passage then would say that we need data, and if it's not available yet, then we must source it. So I hear the argument of the deputy minister to say this is now high up on the order paper, and as it is, he's of the view.
Sorry, Honorable Han, can you repeat your last point?
My last point, Chair, is that I believe where paragraph 36 of Minister of Home Affairs versus Nikru clearly distinguishes or say there is a differentiation to be made as to in which circumstances justification depends on factual material. If one reads that with section 90 of Kwalani, where the court says criminalizing unlawful speech must be a measure of last resort if other measures have proved to be insufficient, then I would want to argue that in determining whether we need data or not, that specific section must guide us. And while I understand the minister has now made use of the opportunity to explain to South Africa, in his view, the stance of the DA, etc. So let me also say, while I understand that the minister is under some pressure for this bill to be finalized so that he can tick that box and say to his political principles that he's delivered, our view is just simply this: we are under a constitutional obligation to make good laws and valid laws. The submission today is in no way an attempt to get this off the table. The minister, deputy minister, sort of indicated that he's still of the view that we don't want this law. We at this stage are fully committed to working constructively to try and get to a point where we can pass a constitutionally compliant law. And if in the end it turns out that in our view we didn't, then of course we will have the right to vote against the bill. But for now, we are fully committed to get to an end product which hopefully we can all A, support, and B, which the courts will not strike down. And then lastly, Chair, I just want to say in response to Ms. Pillai's input, I think she was very helpful in the sense of confirming that commitment to justifying a limitation of the right to freedom of speech. I just would want to ask her and the department to also consider whether, given the two cases which was dealt with in our submission, whether there can be a situation where you preemptively, by way of criminalizing speech, can validly validly pass legislation. The gist of our submission, Chair, is that you must first look to measures other than criminalizing speech, specifically if one talks about that expanded list. And if that turns out to be insufficient, then of course, as a measure of last resort, you can criminalize. So with the greatest of respect, I do believe these two cases give us clear direction that we can't preemptively, on the basis of foreseeing that a specific ground can in future become problematic in South Africa, already now criminalized. And I would plead with the department to carefully consider this specific aspect. Thank you, Chair.
Thank you very much, Honorable Horn. Members, before Honorable Jelle takes the floor, can we have a 5 minutes comfort break, coming back at 10:55? Welcome back. Honorable Jelle, over to you.
Chairperson, good morning, Chairperson, and also good morning to the colleagues and DM and the team. I'm not sure, Chair, if maybe they are going to flight. The team is going to fly the presentation. But my presentation, Chair, is very short and to the point. It was informed, or it is informed, Chair, by our last meeting when we were given the list of characteristics and the grounds. Chair, from that point of view, Chair, I saw that earlier I proposed that there must be in one of the characteristics of the ground that was put forward, there was the issue of color, Chair, and I requested that we should put skin in front of color. Hence, we are here today about the issue of the skin color. And also that it is the department did not make an accommodation that the issue of skin color be also lifted on the ground. Before I start with my presentation, Chair, I just want to remind the members that, Chairperson, apartheid was declared a crime against humanity. And secondly, apartheid was legal, Chair. And it was also a system, it was structural, Chair, and it has laws which were enacted to entrench it, Chair. And those laws impacted so much on the nation, particularly of South Africa. My presentation, I think the issue of color, Chair, if you can check, and members can also note, it deals with the issue of race. And it is right in the Constitution, Chair. And last week we were given a presentation by the department in terms of section 16, subsection 2 and section 9, subsection 3, and also PEPUDA, Chair. That race appeared in all of those sections, Chair. And also, if you go to Chair, section 9, the issue of, in fact, the color covers cut across, Chair. But this presentation today, Chair, from the presentation as it is, you can see that it's a motivation that the committee must find it in itself that we must put this matter of skin color, of color, to rest. I don't see it belonging anywhere except here, Chair, on this issue of hate crime and hate speech. If you check, Chair, you go down, I've listed the legislations, and these are not the only ones. There are a lot of them, Chair. And then also, Chair, I decided to go deeper, just not deeper per se, just to go through the definitions from the dictionary as to the color. I want the committee to note that color was originated, it's somebody's invention. It is for us to be where we are. Somebody invented a color, and that color was given categories, Chair, in terms of the red, the white, the blue, the black, and all those things. But now, my point is that, Chair, the issue of color, it was used in the apartheid setup in order to discriminate against a race. And I wanted just to bring the committee by coming up with just simple dictionary meaning of these colors, but particularly the two colors. And also, Chair, on the issue of religion, how is this color impacting? On the first one, Chair, the definition of color in relation to this, I mean to say, a definition or meaning of color in relation to skin color, according to the dictionary here, Chair, on this presentation. It says black is the opposite of white. Here it says belonging to or denoting a human group having dark color skin, especially of African or Australian Aboriginal ancestry. And then it also says, Chair, that it's the dictionary, black adolescents of Jamaican descent. That is the some of the words that I found when I was checking the dictionary. And then here they say the color meanings. Black color symbolizes power and sophistication. And it says also, black evokes images of death, misfortune, and evil spirits. It is said it provokes deep-seated sadness and distress. And therefore, Chair, when I looked at this, I just felt like there is no one who would want to be called black as a human being, because this, it must be something that is really not sitting well to those that are called by the color black. And going down, Chair, meaning of the color black in the Western countries. Black is the color of mourning, death, and sadness. Black often represents the strong emotions and actions of rebellion. Chair, my motivation is that there's a race in South Africa that has been named as black, Chair. And let me go to the meaning of white. The white, Chair, it symbolizes, it is the symbol of goodness, God, and eternal life. God is light, and therefore light represents white, Chair. These are just meanings. Sometimes we use these colors just anyhow, Chair, but they impact too much to those who are called by those names or colors, Chair. Let's go down. Can the secretary take it? And then let's check the meaning of black from the religious perspective, Chair. It says here the color black represents sin, evil, and death. Black darkness symbolizes suffering and death. It says it is from the Bible, but I think we can get lots of references on this, but the examples, because I wanted to take it straight from the dictionary, it just gave us that verse. And also, Chair, when in a simple, if you go to the dictionary, you just click Google black, the first thing that is going to come, Chair, it is the images of the devil, always painted black, Chair. And then I wanted to check the harm of this color, skin color, the color, this color black. It cuts across all ages, the harm, Chair. Deep scars of emotions and psychological disturbances and the damage, Chair, caused by this. It's deep, Chair. And then I want to go to the history because I want to go fast so that we can come to the discussion, because this is just a motivation so that you can understand from which angle I come from, Chair. The background I'm saying here, Chair, the skin color in South Africa, having provided the above information, the meanings of the simple dictionary clearly, Chair, was as a result of hateful and discriminating intentions towards certain races, particularly those that are called blacks and colors. And one of the highlights of apartheid was racial classification. It is now an open secret that apartheid was legal and had structural systems. It was structured, Chair. Racial classification was one of the weapons used, and it had 4 groups. There was white color, black color, and then, I mean, in terms of the races. And then we had the Indians. That's what we have here in South Africa, Chair, right currently now. And then we have the colors. In the world, amongst all nations, including here in South Africa, Chair, blacks, colors, whites are the only races called in a very demeaning, degrading, undignified, particularly blacks and colors, and discriminating in a discriminating manner. There is no doubt calling these races with such names should have came with deep, hateful, destructive intention towards those directed to them. Unfortunately, these were the results of the pervasive system of apartheid, which have been so deep that today, as a country, one nation, as a nation, we find ourselves not being able to move forward as a united, non-racial, non-sexist, and democratic rainbow country that we envisaged before 1994 democracy. And therefore, the proposal that I'm bringing forward to the committee, Chair, that skin color form part of the grounds, not only listed as the characteristics for the purposes of the proposed hate crime and hate speech bill, is not for anything else, but just to try and correct the ills of the past and assist fight against racism in the country. Chair, there are so many, in fact, there's one case that I've read about. They are saying, in fact, that case is the one that is more famous. They are calling it the VC Wilkinson case. Chair, if you read, you will understand how is this thing of categorizing races was done. The example of racist nations, nationals in South Africa, Chair, we have blacks, we have colors, we have whites, we have Indians, Chinese, Nigerians, Congolese, Zimbabweans, and Malawians. And in other countries, Chair, African countries, all nations are called by their countries. Even in Europe, they are called by their countries. Blacks, whites, and colors are the only ones that are not called by their countries. I'll tell you why, Chair, I'm bringing this now, Chair. It is because, Chairperson, this issue of skin color, it has caused so many damage in amongst us as racist, as racist nationals in South Africa. The issue of hate speech, Chair, we know that the issue, in fact, there's a law that says people, we cannot be called K with a K weight. That K weight, Chair, that it won't subside, it won't go anywhere. Unless, Chair, we go down to deeper to correct what the apartheid did to segregating us, categorizing us with the colors. It will never go because others will see themselves better than others. And there will be some words that will be spoken. And Chair, as I'm talking to you now, it is happening daily in the crashes. It is happening daily, hatred towards certain colors, certain skill color people, Chair. It is happening, it is the life. So in conclusion, Chair, is that the issue of apartheid, slavery, colonization, and its deep emotional and psychological results left the South African nation badly broken. Now it is up to us to try and repair what is repairable, close the gaps without opening the wounds. We have an obligation in terms of the Constitution of South Africa and international human rights prescripts to assist to fight racism in the country from all corners. This submission is meant precisely for the reason it is intended to motivate to the Justice Portfolio Committee for the skin color to be added as one of the grounds. At the moment, it is listed as the characteristics, Chair. So I propose that, can we bring it down? I will motivate further, Chair, if requested, but I just wanted to give this as a background why I want skin color to be included there. Thank you, Chair.
Thank you very much, Honorable Maseko Jele. Are there any questions or comments? Honorable Yako.
Thank you very much, Chair. I think I just want to, it's not a question, it's just a comment on the Honorable Maseko Jele that I want to support her. I didn't understand initially when she was raising the point of the skin color instead of just color. And I think that this presentation clearly outlines her passionate feelings around the issue of skin color, and it makes sense to me. So I just wanted to affirm her that thank you for this presentation. It's made an impact to me personally. Thank you.
Thank you very much. Any other views? Honorable Swart.
No, Chair, I appreciate the input, and I'm deeply sensitive to the issues that the Honorable Maseko Jele has raised. I do, to a certain degree, understand that there is an added element with skin color as opposed to mere race. But then one wonders why the drafters of the Constitution seemed, and I stand on the correction, but seemed to have included this concept of skin color under the concept of race. And that is one thing I am just wrestling with, given the deep sensitivities that the Honorable Maseko Jele has raised. Yes, and I appreciate her reference to the scripture of Job. There's also wonderful scriptures in Song of Songs that says, for example, I am dark, yet lovely. So there are other scriptures that do reference in a more positive light what the Honorable Maseko Jele was referring to, but I am deeply sensitive to what she was raising, and we need to deliberate on that with a deep understanding of the sensitivity and emotions that have been expressed. Thank you, Chair.
Thank you very much to Honorable Swart. Any other views before we ask Honorable Jele to respond specifically to the question that Honorable Swart has raised, that it is not always negative. There are also instances where it has been put in a positive light. Any other questions? Over to you, Honorable Jele.
Thank you very much, Chair, and thank you very much also to my colleague for their comments. I agree with Honorable Swart. There are a lot, in fact, he's correct. But Chair, these such verses are the verses that makes us and help us as people who are called Black to move forward, even though it hurts. They help us to be able to see, light in that dark channel where we are called something that we don't want to be called with, Chair. So I understand very well, I agree with him, but I still maintain that it hurts, Chair, to be called by a color. When you are not a color, when you are coming from that, from a country like any other person who is called, called by their countries, we want to be called like that so that we can be respected. Dignity must come back to us. so that when people look at us, they don't see color, they see a human being coming from this country and called that you are a South African. I would appreciate to be called an African or called a South African, but not Black, Chair. That hurts. We are quiet because we were forced into that situation. And I'm sure even not, I don't want to personalize it. I want it to be something that it is rational and everybody is able to relate to, because we are, even the white people are called white. Maybe even the colors, they are called colors. And if you can see here in South Africa, Chair, we are even discriminated further. All those colors, white, colors, and blacks, we are discriminated further, Chair, within ourselves, because even within ourselves, we have categories of colors. You are lighter, you are darker, you are this. So it is even getting worse. So for me, if we want to correct these issues, we should not cut and paste. We should just go to the origin and sort this thing from the origin, and then other things which comes with behavior we'll deal with. Thank you, Chair.
Thank you very much, Honorable Jale. And then maybe let's think about how is it going to happen in practice. Honorable Jale, for instance, there would be organizations who would call themselves Black People's Convention, Black what and what. What do you say to that? They have voluntarily chose to use, they are Black, they voluntarily chose to use that word.
I agree, Chair, that I wanted to, in fact, my answer is going to be the very same answer of saying we ended up, or people, nations, races, ended up accepting that we are Black. That is why we have that verse in the Bible where somebody is saying, I'm Black, I'm beautiful. So that the very same organization came to, but yeah, let me come to the real point of saying, what am I saying to those organizations? Everybody has a choice, Chair. If there are those who feel they want to be called Blacks, but if this point we take it as a country and resolve it at the level of national, other things will fall, Chair. I'm not sure if maybe I am able to convince you. Maybe some other colleagues can also assist on this one. But I'm saying other things, we use them as the mechanism to accept the situation as it is, because there was no way that we can change it. Maybe if you call yourself Black because you want to call yourself like that, it's fine. But it should not be the issue of saying, even the statistics of South Africa it is categorized as Black, white, green, yellow. It shouldn't be the issue of us as the country wanting to force that on people, and they should understand it like that. So it will be the issue of choice. We are Africans, whether you are white or you are Black, you are born here in South Africa, you are a South African. So you deserve to be called a South African, not a Black or a white or a colored. So if you happen to want to call yourself that, it is another issue, Chair. Thank you.
Thank you very much. Any questions from the department or any inputs from the department on that issue or responses? None. Can we now proceed? I take it, Honorable Jale, there will be no need for you to have closing remarks, because I think you answered, you responded to Honorable Swart's question. You have also responded to mine. Maybe I must not take it away. Maybe your closing thoughts. No, yeah, let me just give you your closing thoughts before we move to the next presentation.
No, Chair, for now, I'm happy. Let's just, okay, thank you, Chair. For now,
Thank you very much. I think let's come back to the department. We asked you last time to do sort of a document that will list these grounds, one in relation to the limitation clause. I think it was issue of a limitation clause and proportionality, that the grounds and the characteristics. That is what we asked that you do last week. I think the first question, to be fair to yourselves, were you able to do that for the purposes of this meeting?
Mr. Chair, unfortunately not, because we wanted to study the submission by Mr. Horan, but we will submit a written representation to the committee in that regard. I apologize, Chair.
No. I think all of us would have taken that view. Especially that we have had substantive presentations from both Honorable Horn and Honorable Jele. I think it was reasonable on your side to take that view. So can I suggest, members, that that be done? Because I think it goes to the crux of our discussions for this particular bill. I think that would assist us to move forward. Can I suggest that next week, let me look at the program, but our program is a living document. Let me just look at the program. And I would ask the committee secretariat to also assist, because in our discussions, we have made certain proposals to be considered by the committee. If we have to look at next week, 15 November, we will be meeting with the two ministers, to deal with oversight issues. And then deliberations on the cannabis bill for private purposes. And I do think that because that meeting will be in the morning, I don't think there'll be enough space to deal with the cannabis for private purposes. And I would suggest that therefore, we leave Tuesday for that meeting of oversight issues, because it will be both correctional services and justice issues, especially your infrastructural issues on both justice and for correctional services, that we take the cannabis bill to be for Wednesday. Wednesday we deal with, and then on Friday we can, because I think we have already dealt with the issue of the briefing by the department on the implementation of integrated immunity management system. I would propose that on Friday we get that document from the department that would be in fact responding to the issues that we have raised. And then we would rework the program accordingly, because I think it would be important that we, after the workshop, were able to slaughter cannabis, and also on that Friday of progress report on NPA and TRC cases, maybe we can have, we'll have a longer discussion also on the cannabis bill and hate crimes bill. So we might start having longer days for both cannabis and the hate speech bills before we adjourn. But we will be looking at the progress we are making. But we do think that the cannabis must really be pushed towards its finality. And then we'll be trying to push also to ensure that we do have progress that we're making with respect to this bill. So my proposal is that we allow the department to go and respond on these issues by Friday when we meet next week. Will that be in order?
Yes, Chair.
Chair,
Yes, Chair.
I just need clarity. What are we going to deal next Friday then with hate speech?
Yes, we're dealing with hate crime, hate speech next week, Friday.
Thank you.
It will be the 28th. No, not the 28th. Where are we now? 16. Yeah, we're supposed to be getting a briefing by the Department of Correctional Services, and we have received that briefing. So we will deal with this one. Members, are there any objections to the revision?
It's fine, Chair.
No objections. I think that would bring us to the end of the meeting, because I don't think that I think we have exhausted all the issues that we needed to deal with today. Honorable Breitenbach, any update on the meeting of this Friday, the workshop?
Yeah, Chair, everything's sorted out. It's good to go. And everybody knows what's expected of them. So I'm not I would however urge you, Chair, to reconsider the decision to have the 2-day workshop with Professor Munting virtually. I will try and find a venue, and that's within walking distance of Parliament. But I would really urge all the members to reconsider doing this in person, please. That's as far as one sorted.
Okay, one of the issues that maybe we might need to do is for maybe tomorrow, after we have received the briefing. I've not had UTM. After we have received the briefing by the judge, the ombudsman, maybe we should finalize that issue of the letter that we have received from the speaker, the person who must sit on the panel. I urge political parties to talk to one another so that we can have a name that we would recommend to the speaker. And I also think that maybe members, the issue that is being raised about a physical meeting, maybe let's finalize it after the workshop on Friday, so that we can, let's finalize it after the meeting on Friday. Honorable Deputy Minister.
Chair, thanks. I don't know if you wanted me to respond to Mr. Swart's question about 16.2, or whether you want us to do that next time.
What is, maybe I should...
the issue when it comes to incitement, that 16.2 is specifically refers to hatred that's based on race, etc., and that constitutes incitement to cause harm. Yes, that is what is in 16.2, but in this bill and in Papuda, we've used the limitation clause to have a different formulation, and that formulation, that formulation is to be harmful or incite harm and promote or propagate hatred. So in terms of Papuda as changed by Kwelane, incitement is only a part, and it's not a necessary part of the crime of hate speech. It can simply be harmful and promote or propagate hatred. And the issue, and it was also with Honourable Horn, the EFF case is about incitement and inciting a crime, which is different to hate speech. But I don't know if that clarifies it for Mr. Swart.
No, I think, DM, maybe we should, it should be part of the ongoing debate. I think, thank you for the clarification, but I would think that it would be a continuous part of our ongoing debate, because I think when the department comes on Friday next week, I suspect that other parties will still want to raise it. But I think, thank you very much for the clarification. The issues that are in this bill, some of them are quite heavy. So let's continue to engage, and we will revisit. In fact, we will not necessarily revisit, but we will continue to engage one another next week when we received the report from the department. Thank you very much, Deputy Minister, for that clarification. I think in the absence of any other issue or issues, can I now close the meeting? The meeting is adjourned until tomorrow. Tomorrow we will be receiving a report from the Ombudsman on the issues relating to the legal services. Thank you very much. The meeting is adjourned.
Thanks, Chair, and thanks to the members.
Thank you very much.
Goodbye.
Thank you.
Thank you, Chair.